It's Friday afternoon. We've turned off the phone, locked the door, and thereby guaranteed that no one will try to give us the terror-rona, because it's time for another edition of our weekly podcast, Tales from the Brown Desk. I'm Jake Rigney of Rigney Law LLC. With me, as usual, is my law partner, wife, and Nestle Water Rights truther, Cassie Rigney. Our host is Terry Ulm. Friendly reminder, Tales from the Brown Desk is a free-flowing conversation involving two foul-mouthed attorneys. It may include graphic descriptions of sexual activity, violence, and recently vetoed House bills. It almost certainly is unsuitable for children. Listener discretion is advised. Here's Terry.
Hello, everyone. Hello, Jake and Cassie.
Hello. Welcome to the coronavirus edition.
Oh, we'll be talking coronavirus.
Yeah. Everyone must think we're like the worst bosses in the world because we're sitting here doing a podcast with our employee during the stay home.
We're 6 feet apart.
We're pretty close.
Yeah.
6 feet.
Yeah, we're 6 feet apart, and we were all coming in today for one reason or another anyway, so we figured while we were sitting here, let's talk about what everybody wants to talk about. Legislation.
Well, actually, we're going to start with a listener question from our first podcast.
Okay.
Jake, you mentioned your number 2 misconception when it comes to criminal law, and that was the number 2 one was when asking an undercover cop if he was a cop, do they have to tell you? And so the listener question is, what is your number 1 misconception?
Oh, what is my number 1 misconception? My number 1 misconception is that when the police arrest you, they have to read you your rights.
They don't?
No, they do not have to read you your rights. But I don't know if it's from Law and Order or from some other type of media or something. Somebody's got it in their head that whenever the cuffs go on, they have to read you your Miranda rights. And if they don't, your whole case is going to get thrown out next time you see the judge. And that is definitely not the case. But it's a myth that seems to persist. And I don't know why, but that's my number 1 misconception. The police do not have to Mirandize you when they arrest you. That's the number 1 misconception.
Do they often, though?
Well, they oftentimes do, but Miranda is related to statements you make to the police, and that's it. A violation of Miranda just prevents those statements being used against you. So, I mean, they do if they think they're going to talk to you and they think that they're in a circumstance where they would have to, if they want to use that in court, because sometimes they don't have to read you your rights and they could use those statements. But if you're in police custody and being interrogated, they have to read your rights. So, I mean, the police want your confession to be usable, certainly. That's what, I tell potentials all the time. There's almost no evidence that's more powerful against you than your own words. So yeah, they often do read. It's a big net, and particularly if they don't understand the requirements, the safe thing for the officer to do is to read you your rights.
Yeah, but they don't have to. So like if they already have probable cause to arrest you and they already know they're going to arrest you, and they're not going to ask you any questions, they don't have to read you your rights. They just slap the cuffs on, throw you in the back of the car, and down to the jail you go. They also don't have to read you your rights if they're going to question you, as long as you're not in custody. So if you're out there on the side of the road, or you're walking around and the police encounter you and they start asking you questions, you don't have to answer them, but they don't have to read you your rights either. They're just allowed to ask you questions if you're not in custody. Now, if they've got you in cuffs, or they've got a hold of your driver's license, or there's some other reason you would not feel free to leave, and they're going to interrogate you, then they have to read you your rights first.
Well, to use those statements.
Yeah, sometimes they're not going to use
Because
them.
that's the thing. I mean, it's just like you can't say you didn't read Miranda Rights. I'm not going to talk to you. You have other reasons why you don't have to talk to them. But it's only the only thing it does if they want to use your statements against you in court, and a failure to meet that is those statements are out, not other evidence, just your admissions.
Yeah, that's the other thing, right? If they messed up somehow and they didn't read you your rights, all they do is they can't use your statement. So if they already still have other evidence that you're guilty, they'll still go to trial even if you get the statement thrown out. So sometimes just because you have a good Miranda issue doesn't mean that you're definitely going to win, because you can still lose even after you win the Miranda argument. You can still lose the trial.
I'm assuming a lot of people would try to explain their situation and try to, like, I don't know, try to talk their way maybe out of it.
Yes.
I'm assuming you as criminal defense attorneys wouldn't recommend this.
My default is do not talk to the police. People, you're very right. They want to explain their behavior, justify their behavior. The problem is no matter how well they think they know the law, I bet you the cop knows better. And generally what I see, people may deny one crime and not realize they're admitting to another crime. I've seen that. Another one, even a denial. As a former prosecutor, sometimes a denial, okay, you denied it. Well, did you put yourself in the place and time that we are saying that you were there? Okay, you just gave me part of my case. Thanks. And then better yet, the second catching someone in a lie is second only to their confession, because if you are caught in a provable lie, of course the state's going to say, well, if you were lying to cover up something. So I mean, they're skilled interrogators, and off the cuff, just statements of a layperson. I do not recommend it. You do not give a layperson statement over to skilled orators for months. That's how lawyers twist your words. That's how that's a skill. That's what we do. So I don't give them any evidence, is my position.
Yeah, I mean, I can imagine situations where it's okay to talk to the police, right? If maybe there is some kind of just obvious misunderstanding that you can clear up with them right away by talking to them. But that assumes that they'll believe you. And that's not always true. In fact, I'd say it's probably not usually true. But it's always hard to say for sure, and that's why defense attorneys, I think, almost always default to talk to an attorney whose job it is to protect you before you agree to talk to the police. Because the attorney that you talk to, if they have any experience, they'll know whether it's actually a good idea or a bad idea to go talk. And they will think of things that a layperson just won't ever occur to them. That's typically what we say. I have a very good imagination, so I can always imagine situations that would cut against my advice, but usually it's just a much better idea to talk to an attorney first.
Are there certain words or phrases that you should use to state that you want an attorney or try to avoid?
Well, that reminds me of the I Want a Lawyer Dog case. You remember that one, Cassie? Where
No.
There was, I think it was in Louisiana, a guy, instead of saying, I want a lawyer, he said, I want a lawyer dog. And they said that was ambiguous, that he might have been talking about a canine attorney, which doesn't exist. And so that wasn't an unequivocal assertion of his right to an attorney. And so the police conduct of continuing to interrogate him after he asked for an attorney was allowed, because that wasn't unequivocal. So yeah, I want a lawyer dog is not good enough, apparently, which is silly.
Very much so.
Some racism going on there?
Or just lack of general understanding. Yeah, I don't know.
It seems pretty of the basic English. That's Louisiana, you said?
If I remember right, yeah, I think it was in Louisiana.
Well, I don't know about your law school, but I was always told if you're going to look at other states' law, never look at Louisiana or California.
That's true, although they tell you not to look at Louisiana's because it doesn't make sense. It's not like any other state's laws because they were a French protectorate, I think, before they became a state. And so most of their laws are written in weird, like, French versions instead of the English versions of laws that we're all used to. And so they don't work the same way, or they don't read correctly. And so that's why I think law schools tell you not to ever look at Louisiana. And boy, we've gotten way off topic. Sorry.
So my next question is, after coming to a recent realization that people can be arrested and told that they're being arrested for something, but when they go to court, they're charged with something else. So how does that happen?
Well, the process is twofold. The police investigate an arrest on a probable cause standard. They're the first stage. They take the results of their investigation and turn it over to the state, where you're talking about having a prosecuting attorney. It's actually an attorney that decides, that looks at that and says what crimes have been committed and what they want to charge. Now, to charge, you also only need probable cause, but for a prosecutor, the end of the road is beyond a reasonable doubt. So you don't want to just charge a bunch of probable cause only cases because they're all going to be terrible and you're going to lose. But people don't seem to understand that the police don't actually get to decide what people are charged with. And they don't understand that they're all the same. It's a multi-step. So, if a police officer can put together an investigation, turn it over, you could get charged higher, you get charged less, you get charged with something completely different if the prosecutor believes the evidence is there for a different charge.
Yeah, and the police sort of exacerbate this misconception or this confusion by saying, I'm charging you with whatever they end up charging with, strangulation and domestic battery or murder, whatever. And I assume partly it's because that sounds cool. Like, they're like, I'm the law. I charge you with murder, sir. It's very empowering to say that, right? But the truth is they don't have the power to charge anyone with anything in Indiana. All they can do is turn the results of their investigation over to the prosecutor's office. And it's not all the police's fault about that either, because when they arrest somebody, they have to fill out a form and give it to the jail so that the jail knows what they're charged with. So the jail can figure out generally like what wing to put them in. You know what I mean? So the jail needs to know something about why they were arrested in order to figure out what to do with them while they're in jail. And so because of that, on their form, they have a space for the police to write in what the charges are, even though the police can't charge them. But they still have to write, well, these are the arrest charges. And so as a result of the way at least Marion County works, you can look those arrest charges up on the jail's website. So people look up their friends or their loved ones and they see, 6 charges or 8 charges or whatever. And they're like, that's what Jim's been charged with. That's what Chad's been charged with. And then when Chad gets to court, Chad finds out that he didn't get charged with that. He got charged with some other things, and it doesn't make sense. But that's why. It's one of these weird bureaucratic kind of things where if you haven't been inside the system for a while, it doesn't make any sense. But it makes sense to us just because we've seen it so many times.
Now we're going to move on to Governor Holcomb and a bill that he vetoed this week, and it is in regards to rental properties Do you know anything about this bill and have any comments on it?
So I read a little bit about it, and it's kind of a peculiar situation just because of where it's at right now. But so the Indiana, and by the way, I have handled about 2 landlord-tenant cases in my life, so I'm coming at this with just slightly a little bit more knowledge than the average person who's read one article. But Indiana landlord-tenant law has, there are statutes, and they provide certain protections to tenants so the landlords can't just, for example, show up and say, hey, you're evicted today. Get out of here. Things like that. Certain municipalities, certain cities, and maybe even counties had gone further and extended additional rights to their tenants by ordinance, creating additional duties for landlords to go through before they can evict somebody. So it created this patchwork system where, depending on what place you're a landlord in, the rules are a little different. In some places, it's easier to evict people, and some places it's harder. And I imagine landlords don't like that because they always want to get bigger. They always want to have more properties, and the more properties they get, the more different weird rules they have to figure out, the more they have to pay their lawyer to figure them out for them, and the more it costs them money. So it appears a group of lobbyists related to landlords in some way drafted a bill, or got somebody at the State House to draft a bill for them, to make it so that municipalities can't extend additional tenants' rights to people. So Indiana law would be the only laws that could be passed. Tenants or cities can't do more to help their tenants. That way there's a uniformity of rules. Republicans, of course, loving businessmen like landlords, were generally all for it. Democrats were generally against it. In Indiana, the Republicans have a massive majority in the State House, so it passed. But then the Republican governor of Indiana vetoed it. That's what's peculiar. And the reason it's really peculiar is that the Indiana veto, the governor's veto, is not very powerful. It doesn't mean very much because they can override it. The legislature can override it with a simple majority, which means the same people who voted this law into effect in the first place, all they got to do is go back and vote for it again and override Governor Holcomb's veto, and it'll still become law. So that's it's been a somewhat peculiar situation. You usually don't see that because the governor knows that, his veto doesn't mean too much.
Interesting. So now we're going to move on to the governor's powers that he now has in this disaster declaration that has been declared due to the coronavirus. He has issued a stay-at-home order for all Hoosiers. What types of penalties are involved if you don't obey that order?
I believe it's a B misdemeanor is what it is. So it's a minor offense. What's that, 180 days? Potentially in jail. Generally, that kind of level of offense wouldn't get you jail time or anything like that. But I think it's to be told how aggressive enforcement of that will be or need to get going forward.
Yeah, it's a interesting situation, I guess, or it's weird because we're living in sort of an unprecedented time, I guess, or at least unprecedented in terms of the government's response to this sort of thing. I don't think we've certainly had pandemics before, but we've never seen the government react so strongly to one, I think, in our lifetimes and probably ever. The flu pandemic of 1918 was really bad, and they certainly took some social distancing steps in some cities. but I don't know that much of it was as bad as, or it was as severe as this. And I think what's kind of wild is that people who don't have any criminal record can get arrested now just for going outside the wrong way or time, and now they've got a crime on their record. It's a pretty wild response. Personally, I think that really the penalty for it shouldn't be more than a fine. It should probably be an infraction and not a B misdemeanor. You get drunk in public and fall down out in the street, you only get charged with a B misdemeanor. So, that's a bit much just for going outside your house when you're not supposed to.
Now, the stay-at-home order allows some people to go and do things like go to the grocery store and go and take care of loved ones.
Go to your law office and go to work.
Right. What interests me is some of the things that are remained open and some of the things that are closed. One of the things that's remained open is golf courses.
Yeah.
And then one of the things that have closed is, I don't know if it's by order or if they're just doing it out of precaution, is funeral homes are now doing things virtually.
Yeah, that's probably related to the no more than 10 people rule. Because, I mean, if you think about running a funeral home, you don't have control over how many people show up for the wake. You know what I mean? And they don't want to be violating the rule because somebody was popular. They don't have a way to predict that. So that's probably why they're just doing them entirely by virtually. And in case we sound a little confused, it's because there's a bum fight outside our office right now. Remember we were talking about homelessness last time? Yeah. So they're out there in the rain. I can hear them yelling. We can all sort of like, what is that weird noise? Yeah. No, it's the bums. The bums are out there yelling.
The city did put a hand washing station on the street by the trash out front of our office, so I thought that was nice.
That is nice.
However, it did look like the bit section that had the paper towel in it was already like broken off the top, and somebody appeared to have taken stuff. So it was the first morning I came in on Monday. It looked like it had already been vandalized.
You can't have nice things around Indiana, man. It's not. He just doesn't get down like that.
There's this company that has created a social distancing scoreboard. And the data that they're using to create this is our location data from our phones. So they are grading each state and each city on if people are abiding by the social distancing orders and the stay-at-home orders based upon their location. Indiana got a B, but I find this interesting because there's a company out there that has all of our location data, and they're grading us and knowing where our location is. Is this legal?
I don't know.
I assume we don't know because we never read the fine print on all those. I accept.
Yeah, no, I don't. And I'm a lawyer, but I'd be interested. I can't imagine how they would even actually do that. It's interesting. I want to know their methodology because there are about 1 million people in Indianapolis, and there is no way they are accurately sifting through all that data by hand. That's number one. Number two, even gathering all that data is difficult because it wouldn't all be controlled by one company. Even the police, when they do it, it takes quite a bit of work and at least a couple of warrants to make it happen. And then sometimes they can only put you in like a 3 or 4 square mile wedge. So I'd be interested to know how it is they're actually grading or examining that. Something tells me that's probably more fluff than them actually sifting through that data. They'd have to have a supercomputer to sift through the location data of 1 million people. I mean, that's going to be dozens of data points an hour times 1 million people. That's close to 1 billion data points. I doubt they have a computer that can crunch that kind of data.
Well, I know the White House just teamed up with the likes of Google and IBM and Amazon to create the computing power to help combat this virus and the pandemic.
So they say.
How is a computer going to protect me from the Rona?
Cassie calls it the Rona.
Another thing that people have been calling upon Governor Holcomb to do during this pandemic is to release low-level offenders from jail and people that are close to their sentences, close to the end of their sentences from jail. Mm-hmm. Do you agree with this?
I think that I agree with doing it. I don't agree with doing it because of the coronavirus. That's, I think that generally the state would do better and this country would do better if they incarcerated fewer people. If you've got people in for possessing drugs, I don't know why those people are in jail to begin with. I'm not scared of them, So I tend to kind of look at this sort of thing like jail is for people I'm afraid of. And other stuff is for people I'm mad at. You know what I mean? I'm mad at the people who keep using drugs, even after we make it illegal, but I'm not scared of them. I just want them to stop using drugs. But I'm not in the legislature, and they get to decide.
So there was a Supreme Court ruling in 2008, Carpenter versus the United States. And it had to do with how the government can gain access to information on people's phones and whether the police or the government need a warrant to do so. What are the laws in Indiana in regards to this?
About getting into people's phones?
Yeah, like can they do that? Do they need a warrant to do it?
They generally do.
A warrant or consent.
My own consent,
right,
or the consent of my cell phone provider?
No, your consent. In that 2008 Supreme Court case, the U.S. Supreme Court acknowledged that we all have a privacy interest in our phones, that we treat our phones similar to the way we would treat our briefcases or other personal papers, which are specifically mentioned in the Constitution as a thing that's protected. And so because we treat it that way, we have an expectation of privacy in it, that they're very personal things that we keep, they're personal devices that we keep on ourselves and keep our personal stuff in. They're protected by the U.S. Constitution and the Fourth Amendment. And so in order to search it, the police need to get a warrant. Before that, it was kind of an open question. But yeah, in 2008, the Supreme Court said, you want to look in there, you got to get a warrant. Now, you can always consent and waive your Fourth Amendment rights, and then they don't need to get one. But if you're not consenting, they have to have a warrant. They have to have probable cause.
So when you say, like, get into my phones, you're talking about, like, seeing my text messages and the things I have on my phone.
Yes.
But what about my location?
If it's on your phone, on your physical device, then they need to get a warrant to get it. Yeah.
It's just to get in your phone, whatever's in there, and that would include your location.
What if my location is stored elsewhere? Do they need to get a warrant?
Yes. Typically in that situation, what they do is they get either a grand jury subpoena. In Indiana, anyway, this is how they do it. They get a subpoena and send it to whoever has that data, or they get a court order or a search warrant, which is like a court order, and send it to whoever is holding that data so that they will provide it to the police.
Okay, so then that might have been what happened to Florida Man, because Florida man got dragged into a case because Google provided his location data and connected him to a crime.
Uh-huh. Yeah, so this is interesting because she snuck Florida man up on us. Did you see that?
She did. I didn't know.
I thought we were talking about something funny, or I thought we were talking about something real, and the next thing I know, it's the Florida man segment. So what? Florida man was at the scene of a murder, and they figured it out because they searched his phone, or they got a warrant and got his cell phone data.
Florida man was being a good guy, and he was just using this app on his phone for exercising to track his bike rides. And that app, of course, tracking his bike rides and seeing how long he rode his bike for, had his location data. And
it was a Fitbit or something like that.
Yeah, like a little app like that. And it connected him to being in this location at this time.
Uh-huh.
So the next thing you know, he's now in trouble because he is exercising.
Is he in trouble because he was exercising, or is he in trouble because he killed someone?
Well, he's in trouble because Google said he was there when indeed it wasn't him that did it. He was actually on his bike on a bike ride.
He was not there.
Right.
Well, was the information wrong, or this is just the context and the meaning of the information? I mean, I think that's what the problem is. Okay, so he gave his information to Google, and Google gave it up per a subpoena. I mean, this comes down to the confusion that people have around DNA and fingerprints. The evidence was right. He was riding his bike, and it put him near the scene of the crime. Well, just because you're near the scene of the crime, as Jake said, doesn't mean that he did it. And it's just like for DNA or fingerprints, that doesn't give you a timeline. It doesn't tell you a how. So, I mean, that seems to me, if you really didn't do it, maybe lazy investigative work. Okay, step one, these are the people that were present, but what happened? Just because you're present, I mean, number one, being present at a crime is not a crime. So that's my question. I mean, it's one of those things, he could not suppress that. That information, if he lawfully gave it up, it'd be Google's rights that would be violated in trying to get that, and it doesn't sound like they fought that.
So how did it turn out?
He fought it and was dismissed from the charges.
He fought the criminal case,
right.
Not the turning over of the...
Right.
Okay, which is probably what it is. This is what attorneys do, is what is the meaning of that evidence? Not saying that the information was wrong, but what does it mean?
Now, there was another Florida man. So Florida man was pulled over, and his car was searched, and the police found a bottle, and it was labeled lidocaine.
Mm-hmm.
And the police tested it, and their test said that it was cocaine.
Really?
It did. And the guy said, this is not cocaine, but the test said it was. So off to jail he went. He fought it for a long time. Come to find out, these tests that these police officers are using, they're not very reliable. And when it was all said and done, it wasn't actually cocaine. It was lidocaine. Mm-hmm. But this guy sat in jail for a very long time.
Obviously, that's frustrating. At the same time, heck, I mean, the police officer did what he was supposed to do, right? He field tested the substance. He thought it was contraband. The test said it was contraband. He's not supposed to let him go at that point. And believe me, that guy is not the first person. That guy is not the first person to say, those aren't drugs, I swear, when they were actually drugs. That's probably second only to those illegal drugs aren't mine as a defense. At the same time, it is really frustrating that whoever is equipping the officers with bad tests is not paying for better tests, because lidocaine and cocaine are actually not very similar in terms of their chemical makeup. And I did a little research on this issue once. So it's hard to mix them up. They don't usually come up. And this is the sort of thing that would happen a lot if they did, because lidocaine is very common. It's an analgesic. You put it on your teeth to numb them. It's like, that stuff that when you have a toothache, you put it on your gums and then your tooth doesn't hurt anymore. You do that for cocaine too. You can do that with cocaine, but they are not, they're not chemically similar, and lots of people use lidocaine, and they don't usually test positive for cocaine. So it's peculiar that happened, but it's also a shame if that guy sat in jail for a long time. Be interesting to know if he sued and got any money out of him for that. He might not. The police officer did what he's supposed to do.
Yeah, my guess is that it would just stand and they just shrug and be like, "Sorry about you, bro." That is exactly why that field test is not admissible in court.
Right. The normal process, at least in Indiana, is if they field test something, that's fine. But it eventually goes to a lab, and a lab technician tests it for real. A scientist in a lab tests it, not a dude with an associate's degree in criminal justice and a gun.
Right, and this was one of the issues that Florida man was dealing with, was how long it took that lab to test it. He sat in jail for a very long time as the lab was taking their time getting to that.
Mm-hmm. And I was just kind of mean to the police. I'm sorry, police officers who are listening. I know there's some of you out there. Most of them have 4-year degrees. Some of them even have masters or PhDs. My bad.
Yeah, they, in that sense, I don't know if that was a history with that test, but yeah, what else are they supposed to do? From it, it's a very unfortunate situation and it stinks, but how else is it going to work? It doesn't work any other way. We got to have a presumptive test. We got to start somewhere. And that's why that presumptive test is enough for the charge, but I don't believe it wouldn't be enough for a conviction.
I have a wild way to fix this sort of problem. This will never happen again. You want to hear my solution?
Yeah, what's that?
Legalize cocaine.
It's not a bad idea.
There's not a very large lobbying effort out there for legalizing cocaine. But here's the thing. Cocaine and cocaine addiction is a problem that dudes with guns aren't going to solve, right? So stop giving the police officers problems that they can't solve. And the way you stop doing that is you make cocaine legal. You take the money that you used to spend on trying to lock people up for possessing cocaine, and you spend it on addiction treatment to treat the people who happen to get addicted to it. Then you wouldn't have to worry about police officers doing field tests with bad field tests because they're cheaper, because the government doesn't want to spend money on field tests. Take the problem out of their hands. They can't fix it anyway. Oh, you hear that, Cassie? They're playing our music.
Okay.
Time for me to go to the bank. Additional legal disclaimer. While we may discuss legal issues and provide information regarding the law to our listeners, we do not intend to create an attorney-client relationship with any listener. Our advice may not be applicable or appropriate to your legal issue. Please consult with an attorney you have hired to review your legal situation before you attempt to apply anything we said today. Thanks for listening to Tales from the Brown Desk. If you need help with a criminal law issue, please contact Rigney Law at 317-430-7370. If you have a question for the attorneys you'd like to be addressed on the air on our next podcast, please email us at Terry, that's T-E-R-I, at RigneyLawIndy.com and title your email Podcast Question. The attorneys in this podcast do not comment on their current pending cases. None of this discussion is a comment on a current case or strategy, even if your name is Chad or Steve.